This is the Architect Exam Podcast, the official podcast of the Young Architect Academy.
Hey there, and welcome to another episode of the Architect Exam Podcast. I'm your host, Emily, and today we're diving into a topic that affects every single one of us in the construction industry, and that is claims and disputes. Before we jump in, I know you're probably doing something else right now while you're listening to this. You're either at the gym, running on the treadmill, or maybe you're driving on your way to work, so you can't take notes while you listen to this. But don't worry, I've written up beautiful 2-page notes that you can download and print out when you get back to your office. Just visit youngarchitect.com/claim to grab notes on today's episode. Because I get it, we're all multitasking while we're listening to these podcasts. Because who has time to sit down and listen to podcasts and do nothing else anymore? I'm the same way. Even while recording this podcast right now, I'm doing some laundry. Now, construction projects are complex undertakings with many moving parts and multiple stakeholders. So it is no surprise that disagreements and issues can arise. And when they do, they can have significant impacts on project timelines, project budgets, and relationships with everyone involved on a project. So claims and disputes are an inevitable reality in our industry. As professionals, we can't just cross our fingers and hope we never encounter claims and disputes on a project. We need to proactively plan for them. So whether you're preparing for the ARE exam, maybe studying for your CDT exam, or already working in the field, understanding how to handle claims and disputes is crucial for your career. Today, I'll break down what claims and disputes actually are, the common types you'll encounter, prevention strategies, resolution methods, and some real-world examples that bring these concepts to life and will help you remember them. And by the way, if you're studying for the ARE or CDT, we have written dozens of practice questions about these exact topics for the PCM, PJM, and CE divisions of the ARE, and they are at the Young Architect Academy online. These concepts show up frequently on the exam, so be sure to pay close attention. So why should this information matter to you? Well, it's a critical knowledge area for licensing exams. It also has major implications for professional practice, and solid risk management skills can significantly advance your career. Plus, as licensed professionals, we're often trusted to navigate these challenging situations where we play mediator between multiple parties. If you're preparing for the ARE, understanding these concepts is not just helpful, it's essential. At Young Architect Academy, we've made sure that our practice questions are directly aligned with NCARB's objectives so that you're studying exactly what you need to know for the exam. To ensure you're maximizing your study time, it's crucial to focus on materials directly aligned with these objectives that NCARB has made. And as Mike always says, if you're not studying NCARB's objectives, you're just not studying for the architect exam. So speaking of essential knowledge, if you're preparing for the AIA exam, you absolutely need to understand AIA documents such as A201 and the B101. These two contracts form the backbone of construction relationships and define how claims are handled. Understanding these documents is being tested on all exam divisions, so investing in learning them early on is wise. Our ARE bootcamp curriculum has a really strong foundation in teaching these two contracts. All right, let's jump in and start with some clear definitions. First up, what exactly is a claim? A claim is a written request with supporting documentation that's submitted as a right under a contract. It typically happens when parties can't agree on something, and it follows a formal process with specific notice periods and documentation requirements. So think of it like this. When a contractor and an owner can't resolve a change order disagreement, and the contractor needs to take steps on what to do next, the contractor will formally seek additional compensation and start the documentation process, and that is called a claim. So for a claim to be valid, you generally need to demonstrate a couple of things, such as entitlement, causation, and the amount, or what we call the quantum, essentially the amount of damages or compensation that's being sought. So essentially, if the contractor feels they are due a certain amount, they're going to document that, and that will be the claim. So now, what about a dispute? A dispute occurs when a claim that has been made cannot be resolved without bringing in a third party to mediate and weigh in. It's essentially the point where mediation becomes necessary. So think of it like the difference between, hey, we need to talk about an issue that we're having versus my lawyer will be calling you. One is a little bit more lenient, a little bit more fixable, while the tone of the other one is a little bit more intense. So good luck solving that. Disputes represent a formal impasse between contracting parties and often signal breakdown in project level communication. So essentially, what has been happening at a very casual conversation level has now become a little bit more formal and intense and has upgraded to a dispute. They might involve multiple claims bundled together and may require more formal processes as defined than in the definitions of the contract documents. It's also important to understand what a claim is not. So a claim is not simply demanding money or services without a contractual basis to follow it up with. A contractor can't just blindly demand payment without going through proper paperwork and processes, and an owner can't demand additional architectural services without revising the scope of work and the contract with the architect. We call that something else. We call that a demand without legal standing, or in plainer terms, robbery. Thankfully, in construction, we have paperwork instead of getaway cars. A claim is not a routine contract modification. A claim is a bit larger than that. It's not a standard change order proposal or just a requested change that parties go through. All of those definitions are clearly defined in the A201. A claim is, again, it's a little bit upgraded from that. It's a little bit more intense. It's not merely notifying someone else of an issue, which should happen really before a claim arises. It's when something is a little bit more involved than that. A claim is not automatically an indication of bad faith by any party too. When there's a claim involved, that doesn't necessarily mean that things are going south, because claims can happen on even very well-run projects with good people involved.
You're listening to the Architect Exam Podcast, your guide to passing the ARE.
Hey there, this is Michael, and I have a quick favor to ask. If you're finding value in this free ARE podcast, please take a second to follow, like, subscribe, and leave a review or a comment on whatever platform you happen to hear this podcast. Your engagement lets us know that people are actually listening, and it inspires us to keep creating more podcast episodes. But honestly, what matters most to me isn't the likes or the follows. It's sharing this podcast with others who need it. When I was studying for my exams years ago, I felt completely alone, and everyone was hoarding information instead of helping each other out. And it was that frustration that led me to start Young Architect back in 2014 with a simple mission: help the next generation of architects become the most successful generation of architects. So please share this podcast with your colleagues, friends, or anyone tackling their AREs. By sharing knowledge, we all rise together. All right, back to the podcast.
So we've covered the basics of what claims and disputes are. Now let's look at the most common types of claims you'll encounter, organized by who the claim is against. First, we'll review claims against architects. These often involve professional liability issues, such as failure to meet architect standard of care, maybe design errors leading to constructability problems during construction, or maybe there's an incorrect specification of a material or system within the contract documents. These issues are also called errors and omissions claims. Missing elements in drawings or specifications, or maybe contradictions between documents or inadequate details that require clarifications, are a form of a claim can be made against them and are errors and omissions claims. There are also design deficiency claims, which can arise when systems don't perform as intended. There are code compliance issues or maybe sustainability targets that aren't met in the design documents. There can also be schedule-related claims against the architect, and this happens when architects are maybe slow to respond to an RFI from a contractor, or maybe they take too long to approve a submittal from the contractor, or maybe when extended services are needed due to project delays. We never want any of those to happen to us as architects, but it's good to know that they can happen. So next, let's review claims against the contractor. So there can be workmanship issues, which are common claims against the contractor. And this is when the contractor has a failure to meet the specifications, or there is poor quality installation or non-conforming work that they've completed. The contractor can also have delayed claims, which arise when contractors fail to maintain the construction schedule or don't provide adequate manpower to complete the job, or maybe they poorly coordinate the different subcontractors across different trades together. There are also performance problem claims, which include failure to achieve specified testing requirements, such as systems installed not functioning properly or as they were supposed to. And there could also be warranty issues. There are also contract administration claims, which involve improper documentation procedures, failure to provide timely notices, or inadequate quality control procedures followed during contract administration. There are also claims that can be held against the owner of a project. So some claims against owners are payment delays, which are a big one. This is when the owner is late to complete payment on a job, such as payment application. Late payments can affect the project cash flow, which can lead to issues with, project schedule, and they could also cause issues with improper withholding of retention or retainage of a payment. Or they fail to process a change order promptly, which can lead to delays and cost more money as well. Owners can also have claims against them with site access issues, which include restricted work areas or maybe parts of a job site that a contractor couldn't get access to because it was closed. This can cause coordination problems with existing operations, or maybe inability to fairly assess the site because there was undisclosed site conditions. So this can be an issue that the owner, again, would be causing on the project. There could be information delays, and this happens when owners make late decisions that affect the project timeline, which would then change requirements in midstream during construction or during design. And owners may fail to provide critical information that architects and contractors need to successfully render their services. So that's a claim on the owner of a project that could happen. And there could also be project management issues that might arise from excessive interference in contractors' means and methods. There could be poor coordination of multiple prime contractors if the owner has opted to do that. And there can be an unreasonable rejection of contractor submittals. So, that friend that stands over your shoulder, maybe like while you're cooking, and they're constantly giving you suggestions and unsolicited advice as to what to add and do to your meal. Imagine that, but like during construction, and it's not just your recipe that's at stake, it's a $1 million project. So those types of interference can really stack up quickly and really affect a project. There are also claims that can happen against third parties, such as subcontractor disputes, which include pass-through claims from subcontractors to the owner. There could be scope gap issues between trades and payment disputes. There could be supplier issues as well, involving a specific type of material or system for the project. If there's a quality problem or a delivery problem from a supplier, perhaps a material is discontinued, that can lead to project costs and delays, and there can be a claim with regards to that towards the supplier, which is the third party. And there can also be claims from adjacent property owners to a project site, which might involve damage from construction activities. Maybe the project being built has caused some damage next door. Neighbors could complain about noise or dust that's happening due to construction happening next door. And there could be unforeseen utility or easement issues that happen, and therefore adjacent property owners might actually make a claim against the project. So those are the types of claims that you may encounter throughout various projects. Now let's talk about something that hits everyone where it hurts: the cost of these claims. So the cost of claims and disputes go way beyond just the settlement amount to resolve these issues. Let's break down the real price tag of these issues. The direct financial costs include legal fees, hiring attorneys and lawyers to deal with all of this, which can range from $300 to $800 per hour. At those rates, you'd think that they'd at least bring coffee and donuts to these negotiations. But then there's internal staff time dedicated to the claim and processing all the paperwork involved. There's also often expert witnesses fees where they come in and they weigh in on the work that is done. And those also will cost anywhere from $200 to $500 an hour to have those expert witnesses give you their breakdown of what they believe what happened and what should happen. There are a lot of administrative costs involved with document management, staff time for claim preparation, and technology costs for e-discovery, sharing all of the discovery of the claim or dispute that's being shared. All of that needs to be shared amongst parties. And then there's the actual payment or the settlement of the judgment that is made of this claim, which can typically be 5 to 15% of the total contract value. So if you add that 5 to 15% just for the settlement on top of expert fees, consulting fees, all of the analysis that had to take place, specialists and forensic accounting that had to take place, it can stack up quite quickly. There are also several indirect costs that can add on to this. So of course, you're processing the claim and the issue itself, but what is a result of having to process the claim? There's probably a huge delay on your project. So that can lead to extended overhead costs of what your original project budget was. So the overhead costs can increase by 5 to 15%. And then you may need to accelerate the rest of your project in order to finish. So acceleration expenses to recover the lost schedule time can also increase your costs, your project budget costs. And then there is also another cost, which is the lost opportunity cost for future projects, whether it's the contractor, the architect, or maybe subcontractors. They're not able to move on to the next job as quickly as they thought they could because they're now making up for lost time because of this claim, and there's a cost associated with that. So team productivity also takes a major hit when there's a claim and dispute on a project. Management gets distracted from current projects and efficiency drops due to documentation requirements that they have to process. So the staff time gets diverted to claim support instead of what their day-to-day procedures were. And that can lead to a lot of stress and burnout amongst all team members. So suddenly everyone needs to become a legal expert instead of, just doing their actual job that they were hired to be there for. The administrative burden involved, in all of this document processing and retrieval, preparing for depositions, maybe, if you're going to court, responding to requests from lawyers and attorneys, and managing the time spent to actually come up with a strategy for these hearings and meetings. That takes a lot of time, and it is a huge administrative burden. There's also the relationship cost amongst all parties involved on a project and a claim and dispute, which can really be the most damaging long term. So professional relationships suffer when there is a claim and dispute. This can lead to a lot of issues. It can lead to a loss of repeat businesses, whether it's with that contractor or that client. There could be difficulty partnering on future projects because of a strained relationship as a result of a claim and dispute. There could be strained negotiations on future projects or impacts on having professional references on future projects. So nothing says, let's never work together again, quite like a 3-year litigation process following a claim and a dispute. So it's like the construction industry's version of a bad breakup, except there's a lot more paperwork and probably higher bills. Team morale and collaboration deteriorate when there is a dispute at hand. And if there is an adversarial atmosphere, it's going to just really eclipse, the working relationship that everyone may have had previously. So, the strategy moving forward from a dispute may create defensive documentation practices, being extra diligent on those meeting minutes and documenting nonconforming work. It suddenly gets a little bit more intense because everyone's trying to act in a defensive way for any future problems. Maybe there's less information being shared, we don't maybe just email over the drawings whenever they ask for them. And the focus suddenly shifts from project success to claim positioning, which can really be harmful for, a positive experience on a job and a project. There are a lot of timeline impacts to consider as well. There's different resolution methods when there's dispute happening on a project. So keep in mind that negotiation, which, maybe is the first step, typically can take 1 month, maybe 2, maybe 3, 1 to 3 month timeline. There is also mediation, which might need to happen if the initial negotiation process doesn't go well. So mediation can take anywhere from 3 to 6 months, right? That can take a while. And so you're already stacking up this time against your project schedule. If mediation doesn't go well and you kind of need to go to the next step of the process, which is arbitration, that can take anywhere from 6 to 18 months. So you're really hoping to kind of resolve this dispute as quickly as possible. But if you go to arbitration, it can take that long. And then lastly, which is kind of the highest level of where this dispute can get to, is litigation, which can drag on anywhere from 1 to 5 years. And unfortunately, some projects do have to go through that if something cannot be settled sooner. And these timelines can mean huge project delays, extended schedules. The owner of the project can't occupy their building as soon as they'd like, and it really cascades impacts on all stakeholders of a project. So it's good to know that, just preventatively, good to have those timelines in mind and have that knowledge at hand. And now that we understand all the cost and schedule issues involved, let's share some real-world examples of how these situations actually play out. So I'm going to share a case study with you of a design error claim. And this is a real-world example that's going to illustrate how claims work. So this case study involved a multi-story office building project where there was a discrepancy between the architectural and structural drawings. The architectural drawing showed incorrect dimensions for structural elements, and this wasn't discovered until steel fabrication was already underway. The error affected floor-to-floor heights by 8 inches and impacted the MEP systems due to reduced plenum space. That might not sound like much, just 8 inches, but in construction, it's the difference between a no problem and everybody panic, we have a problem. The contractor discovered this issue during coordination meetings and immediately issued an RFI identifying the conflict. The architect acknowledged the error in coordination, and the contractor submitted a change order request with the full cost impact of that issue. But when that change order request was presented to the owner disputed the cost of the change order and claimed it was excessive. And now the architect's insurance carrier has to become involved due to the architect's lack of drawing coordination. So the negotiation failed, the negotiation being that the contractor proposed a change order for the cost that they needed for the issue, but that change order was rejected, right? So the negotiation failed, and therefore a formal claim needs to be submitted. So here's how the resolution of that is going to unfold. So first, project level negotiations, again, they were unsuccessful. Then there must be an executive level meeting between all the parties involved. When that doesn't resolve things, they will schedule a mediation with an industry expert and bring in an independent estimator for a detailed cost analysis. So essentially, they're gonna get a cost analysis from an independent estimator to kind of compare it against the contractor's cost. Eventually, they're hoping to reach a settlement, which is going to allocate the costs between the parties with the architect's professional liability covering a portion, because the architect did admit that they poorly coordinated those drawings. So the architect's insurance, their professional liability insurance, is going to cover a portion of that cost. So the key lessons from this scenario: the importance of coordinating drawings across all of your consultants as an architect with the architect's drawings before construction starts, and the value of catching those errors during the design phase, the documentation that helped resolve the situation fairly, and the effectiveness of the mediation process. So essentially, because they had mediation and they were able to settle on an amount that was partially covered by the architect's insurance, the dispute did not need to upgrade to arbitration or litigation, thankfully. So next, let's talk about preventing claims and disputes. The best way to handle claims is to prevent them from happening in the first place. So let's talk about effective prevention strategies. So of course, you want to have clear contract documents. They're your first line of defense, and use precise language and avoid ambiguity in your documents. So define terms very consistently and clearly, and specify exact requirements of the project or a system, and clearly define roles and responsibility in the contract documents. So by creating a comprehensive scope definition with detailed descriptions, include all of the work expectations and requirements, and also state clear boundaries between trades and address any potential overlaps or gaps in the documents. Another great prevention strategy for claims and disputes is to have a well-defined change management procedure. So have specific processes for requesting and documenting and approving changes. Have a protocol in place. Have time limits stated with format requirements, like how to respond to these requests. Think of this like planning a dinner party. And then, at the last minute, maybe your spouse invites 20 more people 5 minutes before the dinner is supposed to start. You need to have a system in place to maneuver and handle those types of curveballs in a construction project as well. So also be sure to make sure that schedule requirements are realistic with adequate float time and, room around critical activities. Have some reasonable durations for each activity, and have a clear definition of critical path milestones that you can share with all stakeholders and the contractor of a project. Effective communication practices make a huge difference too. So be sure to hold regular project meetings with documented minutes that track decisions and action items, and then distribute information to all relevant parties after meetings, and also follow up on any outstanding issues that were talked about. Also, at the start of a project, implement a structured RFI process with clear tracking systems. Contractors may like to submit an RFI via email or via a phone call or via text. It really is good to have a system in place from the beginning that is written and documented, and it's good to have that paper trail just so that everyone's on the same page. Documentations of decisions and rationale, having that in place is absolutely required to have clear communication. Think of RFIs as the construction world's version of, can you clarify what you meant by that text? Except instead of it being a hard text to understand, it's a $1 million project and drama that could come from that. So be sure to provide early notification for any potential issues. We don't want to have any surprises on our projects. A no surprise policy amongst the project team is great to encourage from early on. Be sure to address problems before they escalate. Problems will only snowball quickly if you ignore them. And document any verbal discussions in writing, just so that you have something to fall back on if someone says that you didn't say something. Use project dashboards or status reports with regular updates on schedule, budget, quality, and highlight any potential risk areas. Be sure to have that type of status report ready going into a meeting, and then document what was said in meeting minutes. Documentation best practices are absolutely critical for preventing claims. And be sure to create detailed daily reports. This is more for the contractor side of things, but it's great for a project manager or an architect to have as well. You want to include things such as weather conditions, workforce numbers, how many people on the contractor's team were on site, material deliveries, where they are, if they made it onto the job site, and the work being performed the day that you were there on a job site, just kind of observing what's happening. Be sure to distribute any meeting minutes that you take, distribute them promptly, and document attendees that were at all meetings, document what was discussed, decisions that were made, and track any action items that need to be taken. And my favorite is to use photos and videos to document work before, during, and after key construction activities with time-stamped images. Before construction pour, you want to take lots of photos of everything and videos, because once that concrete is poured, you can't see what's inside of it anymore. So it's nice to have visuals of everything with timestamps to know what happened when. Be sure to also manage emails and correspond through a shared system or a centralized system with proper subject line conventions and written confirmation of all verbal discussions. Also, keep as-built documentation with real-time tracking of changes from design documents, regular updates, and verification by all responsible parties. Document everything as it happens, not after the fact, because trust me, your memory after 6 months will convince you that you were completely reasoned about something and everyone else was being difficult, but in actuality, it might have been a little different. So it's kind of funny how that works. Finally, be sure to create a claim resolution action plan before you really need it on a project. Create it from the beginning, just so that if something does happen, you have a plan in place and there's no need to panic. It's a great way to proactively identify any potential claim areas through risk assessment during pre-construction and regular reviews during construction. You can also designate a team member for claim management with clear roles and proper training so that they can be the decision-making authority if a claim happens on a project. And establish a review process with regular timelines for evaluating potential claims, multi-level review, and documentation standards. So this is when you're creating projects and you're at a milestone, but right before you share it with the owner or the contractor, you want to have people in the office, a fresh set of eyes, look over your drawings and pour through them to look for any coordination that needs to happen or any issues. And that is your saving grace before you share them with the parties that will actually be building the project. And it's also a good call to identify any alternative resolution methods in advance with step-by-step escalation procedures, timelines, and available resources.
You're listening to the Architect Exam Podcast, the official podcast of the Young Architect Academy.
So here's another real-world example involving this time a delay claim. So this was a new school project with a strict completion deadline. The project faced an unusually rainy season that exceeded historical rain averages, making it impossible to complete site work on schedule. You know, the kind where you start considering building an ark instead of a school? And living in the Virgin Islands, I've seen my fair share of those rainy seasons. So to make matters worse, on this project experiencing this seriously rainy season, there were also concurrent supply chain issues with structural steel. So the owner of this project was unwilling to extend the completion date due to these delays. And on top of that, the contract had liquidated damages clause for $2,500 per day of delayed completion. So the contract did have a clause about weather. The weather clause required a comparison to 10-year averages. And there was also a force majeure provision for material unavailability, the steel being delayed as well. The contractor met all of the notice requirements and also provided a schedule impact analysis showing that because of the rain and because of the steel delay, that there would be a 45-day critical path delay on the project schedule. So this on top of an estimate of accelerated costs to maintain the original completion date was shared with the owner. So this is like being asked to have a baby instead of 9 months to have a baby in 6 months, right? It's a wild ask. So some things just don't work out that way. The owner was not going to get their building on the original completion date. There was too many factors that delayed it, and the owner was pushing to have it anyway, and it just wasn't realistic. So the documentation that helped resolve this situation included daily weather logs and photos of the site conditions, corresponding with suppliers showing that we were trying to get the steel there on time, on site, and there was just, unpreventable issues. There was updated critical path schedules that were shared as well that showed the impact. So the contractor did a great job of constantly informing the owner of the project what was happening. And there was also tracking of mitigation efforts, of cost, detailed productivity analysis, and alternative sequencing proposals submitted early and shared with the owner so that they could really wrap their head around how delayed this project would be. In the end, the owner did grant the time extension for the weather portion, which was about 30 days, and agreed to share responsibility of accelerated cost to finish the project sooner, even though there were delays. So therefore, there was no liquidated damages that were assessed or needed to be enforced. So the key takeaway of this case study was that there was value in that thorough documentation that the contractor provided to the owner because of the delay that was experienced. And the contractor was really good about being timely with notifying the owner. And there was a lot of benefits to this. The proposed solutions, it was a very proactive approach rather than just being delayed and then getting to that 45-day delayed and saying, hey, sorry, it rained and the steel's not on site, like your project's delayed. The contractor was really good about getting ahead of it, being very clear and transparent and doing those projections and sharing it with the owner of the project early on so they knew what they were getting themselves into. So what were to happen if prevention isn't enough and you're actually facing a dispute? This is when your claim gets upgraded to a dispute and, a third party is now weighing in. So let's walk through that. So when prevention fails and you're now facing a dispute, there's a typical sequence of resolution methods to follow. So first, you're going to start with the easiest, which is, the method of less animosity, which is good faith negotiations. And this is a direct party-to-party resolution without third parties yet. Right? This is just everyone talking to everyone involved in the project, the owner, the architect, the contractor. And this is often required by contract before escalation and has the benefits to preserving everyone's working relationship with each other. There's also a low cost associated with this, and it is the path of least resistance. It is the fastest resolution. This is a great way to start in resolving your dispute because it really promotes open communication and everyone is still focused on project success and they're willing to compromise with the claim that's been made and resolve it internally rather than having to bring in a third party. But if that good faith negotiation doesn't work, let's say the owner of a project is still not willing to compromise on a claim or, a change order was rejected and they're not budging, or maybe the contractor isn't budging or something like that. If that doesn't work, you would then upgrade to mediation. And this is when you have a neutral third party that will come in and facilitate the conversation between everyone. They don't actually make the decision. They actually just kind of weigh in and help guide the conversation for everyone to come to a settlement. So mediation can take 1 to 3 months, and it can cost anywhere between $5,000 to like $15,000. And that's for a straightforward claim. Mediation resolves approximately 80% of construction disputes. Though it's non-binding, parties must agree to the resolution that came through mediation. Some projects establish dispute review boards at the start of a project, and this is when there are panels of industry experts who provide real-time dispute resolution throughout the project with advisory opinions that share their expert opinion on the project. So this is in a dispute review board, the costs are shared between all the parties involved in the project because they knew about it early on. And these boards are effective in preventing escalation to arbitration or litigation. So essentially, these dispute review boards, they act as mediators, but they're established early on, usually on larger projects, just to kind of guide any issues that may come up throughout the project before it needs to be escalated to arbitration or litigation. But if even a review board fails, you are going to need to escalate the dispute to arbitration, which is the next step. And arbitration is a more formal process where arbitrators will come in and render binding decisions. So this is typically specified in the contract or agreed to after a dispute arises. And the timeline is usually 6 to 12 months, with costs ranging from $20,000 to $100,000 or more based on how complex the project is. So arbitration has limited appeals compared to litigation and less strict rules around evidence, but it is the next step in the dispute resolution process. And lastly, if it cannot be resolved through arbitration, the dispute would be then upgraded to litigation, which is the last resort when all other methods fail. The process includes complaint, discovery, motion, trials, appeals. This is when your dispute is going to court. This is when just everything has gone wrong. No one's getting along and no one can agree. There's no other route to take. So this can take anywhere from a year to 5 years until that final resolution is made where there's a judgment made, and it can cost $100,000 or more. And that's for modest claims, based on how complex the project is or how large the dispute is. It can be even more. By then, you might not even remember what the original dispute was about, but your bank account will definitely remind you. Litigation creates public records, and it can significantly impact company resources and personnel time. So everyone is encouraged to avoid litigation. It kind of goes down in history, your business name, the owner, the contractor, the architect. So it's best to try and resolve these things before it gets to that point, but it really is based on the dispute that's being made and the claim that's being made. So before we wrap up on all of these definitions, there are a few more important considerations to keep in mind that are worth mentioning. And the first one is the Spearin Doctrine. So if those of you are studying for the CDT exam, I'm sure you read on this. The Spearin Doctrine is a legal principle establishing that the architect implicitly warrants the adequacy of their plans and specifications. So this shifts responsibility for design defects to the architect or the designer, even when the contractors have reviewed the documents, maybe even before bidding has happened. There are exceptions to this, including the contractor's obligation to notify the architect of any observed issues, and variations of the Spearin Doctrine do exist across different jurisdictions. There's little variations, but essentially what this doctrine is calling out is the architect's issues with their drawings and their work. This is something that really scares us architects, but it's a good legal principle to know and understand in your profession. So the project delivery method that a project has also can impact the claim. So if the project is a design, bid, build project, there is a clear separation of design and construction responsibilities, which may lead to more claims based on design issues. But if the project is a design build delivery method, it actually has a single point responsibility because the designer, the architect, and the builder are working together. So that actually might result in fewer claims for coordination issues. And maybe there's like a different pattern of claims related to the project because of the project delivery style. There's also the CMAR, the Construction Manager at Risk project delivery method, which involves a shared responsibility during the design phase with the builder and the designer, which may reduce claims but creates a complex responsibility matrix between the parties. There are also the IPD project deliveries, the integrated project delivery method. It has a shared risk and reward structure with different incentives that may reduce claims because the goal of that is to have everyone working together on the project's success. So based on that style, it really is going to tell you if there's more or less claims. And that's also based on how large or complex the project is. And finally, we wanted to touch on indemnification clauses with this topic because there is an important risk transfer in indemnity and these clauses. So indemnification actually transfers risk in contracts in a way that is going to provide protection against third-party claims. So essentially, myself as the architect, I don't want to get a claim against me from a third party, so I'm going to have an indemnity clause in my contract. There are different types. First, there is a broad form of indemnification where the indemnifying party assumes all of the liability of an issue. There's an intermediate form of indemnification, which is proportional to a partial negligence contribution. And then there is the limited form of indemnification, which covers only the indemnification party's negligence. So these clauses are subject to anti-indemnification statutes in many states. Again, this is based on the jurisdiction. It's based also on your insurance coverage restrictions, and any enforceable issues that are seen with the project. Best practices include clear language defining scope, consistency with insurance requirements, and reasonable allocation of risk. And one important note, claim laws can vary, again, significantly by location, by what state you live in, especially things like prompt payment acts and lien laws. So what may apply in Florida might be completely different than what applies in California. So always consult with local legal counsel before go on this road to navigating claims and disputes on your own or in your professional practice, as they do change by states. Now, let's bring this all together with some key takeaways. To wrap things up, remember that claims are formal written requests under contract rights, and disputes occur when third-party intervention becomes necessary. So the claim is actually the written formal request, and then the dispute is when that mediator or that neutral party comes in to weigh in and make a decision with you together. Prevention through clear documents and communication is always preferable to resolution after the fact, so be sure to work in a very proactive manner. Documentation is critical for both prevention and resolution methods follow a typical sequence from negotiation all the way through to litigation, but we want to avoid that. All parties share responsibility for a claim and prevention and best practices. So it's not just all on the architect. Contractors should practice these as well as the owner of a project. And some final thoughts on best practices. Be sure to address issues early before they become formal written claims. And document everything as it happens, not after the fact. Maintain professional relationships. Even if there's a disagreement, maybe you don't agree with someone, we're going to keep things professional, keep morale high, and focus on project success rather than winning the dispute, because the real winner of a project is a successful project without extended, drawn-out disputes. You don't want to have to, pull in the lawyers, just to pay them some huge fees so they can send their kids to college. You really want the project to be successful and avoid any of that animosity. So consider claim prevention as part of your project planning strategy and evaluate each project for lessons learned about claims. So what I mean by that is if you did go through a claim and a dispute process on a project, now you know more for the future. Understanding claims and disputes is important for your career development too. Risk management skills are essential for advancement. A knowledge about claims enhances your value to employers and clients. You don't want to be an architect that's just like, oh no, I will never have a claim or a dispute in any project. I'll just avoid it. I think it's good to have the acknowledgement that it can and it will happen and have the confidence to navigate them. Your clients will hire you for that confidence because they would be stressed out to navigate that as well. So any experience that you have with claim prevention, it's going to demonstrate your professionalism, and understanding all perspectives improves team collaboration, and your long-term professional reputation benefits from effective claim management. So that's all I have for today's episode. If you found this information valuable and you're preparing for the AIA exam, I invite you to come study with us at the Young Architect Academy. Our practice questions cover a lot of these topics and more, and they're aligned precisely with NCARB's objectives. So just visit academy.youngarchitect.com to learn more. And remember, if you were listening while you were doing something, you were working out, and maybe you just couldn't take notes while you were listening in, that's fine. You can grab our 2-page notes that we created on this episode. Just visit youngarchitect.com/claim and print them out when you get back to the office. You could read them over and listen to this again if you'd like. Thanks for listening in today. I'll catch you on the next Architect Exam podcast. Bye, everyone.
Thanks for listening to the Architect Exam Podcast. Ready to take your studying to the next level? Visit our online ARE Architecture School website at academy.youngarchitect.com to learn more about how we can help you. See you next time.